This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night. So if you've got legal questions, you've got a legal issue you're dealing with, tonight's your chance to call in and get some of those questions resolved. The 31 Law Call number is 256-536-0077. You can call in and be live on the air, or you can also text us to that same number. We've got some of your text messages coming in. You can also email a legal question on any legal topic any day of the week. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we'll pull some out, and we've got some of your email questions ready for tonight. But it's Ask Us Anything night, and Will League is here.
Well, Sharon, yeah, we're talking about Ask Us Anything. You know, it's summertime, even though we don't have technically a summer at our age, right? But a lot of our kids do, and people are out on motorcycles more. There's, you know, we're handling some horrible boat wreck cases. You know, people are getting out more, which is good. But, you know, the kids are out. What does that mean? You know, the pool safety. Unfortunately, we run across child injuries and death cases this time of year. So be brave. Give us a call. There's storm damage happened a week and a half ago. How are you dealing with your insurance company? You know, and how are those things? So challenge you to give us a buzz tonight or give us a text. 536-0077 is the number. Either one.
While we get some of those calls locked in, we've got tonight's You Make the Law Call video. We pulled this off of YouTube. So watch the camper over here on the right. It's starting to swim right now. A lot of us traveled over the Memorial Day weekend, and you're hauling something you're probably not used to hauling. You get to something like this. Don't know if it's high winds caused this or the speed. When you look at that, and you guys do personal injury cases, so fortunately nobody was hurt in this one and it all worked out. What do you look for when you see something like this?
Well, there's separate rules of the road. When you're hauling equipment, trailers, you know, what type of, you know, do you have safety chains? Do you have braking capability? Is it working properly? So oftentimes, if you brake the car and there is pressure on the tongue of that trailer, the brakes engage. Is that working properly? Was there properly? Was there a pre-trip inspection? We've had several cases where you're supposed to have two safety chains, they weren't attached, or there were no lights, or it was unhooked, it wasn't hooked up properly. I didn't see any brake lights in this particular video, but again, you have an obligation, win or not, to control your vehicle. And when it starts getting, you know, a little bit squirrely like it did, or actually a lot squirrely, didn't see any brake lights, didn't see any corrective measures. And luckily, there was nobody else involved. Hopefully, there are no injuries. But you can be liable when you're hauling things, just like we talked about. Summertime, you're starting to get out of your comfort zone. People are traveling more, hauling things they're not used to. So make sure you have all your equipment working properly for you and everybody else on the road. I mean, we've had that case where the trailer comes off, goes across 565, hits oncoming traffic. You know, there's been fatalities. We've had those cases, and you know, it's on the driver to make sure his equipment's properly secured, attached, and he's, you know, he or she is complying with all the rules of the road, especially when it comes to equipment working properly. In that case, when the officer comes and does the report, they're going to check all that equipment. It'll be in the police report.
You can't say act of God. High winds, it was out of my control.
You know, I mean, there could be a defense, but again, you have the obligation to even check the weather. When you talk about pilots, when you talk about, you know, if you've got stuff that's subject to that high winds and you go anyway, you're the pilot. You are the person in control of that vehicle, and the buck stops there. And if somebody else was around that car, that driver would have been liable for the damage he caused.
Okay. They're telling us to take a break. We're going to take a break, and we'll be right back answering more of your questions. Call in 536-0077.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back. Tonight it's Ask Us Anything night. Will League is here from Timberlake, League & Brooks. We've got callers waiting. Nicole is on the line with a question from Huntsville. Hi, Nicole. Thanks for calling. What's your question tonight?
Hi. Thanks for receiving my call.
Sure.
A company was out, a digging company was out, and they dug a hole that was left uncovered. So I contacted the company, and this guy said he was going to send someone out the following day, but that didn't happen. I gave him another week, called him back, and still nothing. So where do we go from here?
Gotcha.
So you said is it with the city or is it a private company?
The city provided me the name and number of the company who did it, did the digging, yes.
And is this on your property or where is it?
On my property.
Okay. All right, so let's say the city contracts with someone to come out, whether they're doing line work or whatever, and they, damage your property, or they dug a hole, left it uncovered. Maybe it's a hazard, but again, it's your property. Typically, typically the cities they do a great job about trying. That's up to debate, but a lot of people think they do a good job coming out, trying to repair where they go in and dig for lines or whatnot. In your particular instance, the city's responsible, and I get it, they gave you the name of the company that they contracted with. If that's the case, you may want to start with that company. If that company will not come out, I would stay on point and make sure to get with someone from the city to see if you can have that scheduled to cover up that hole or fix whatever they came out to do. Be patient. I wouldn't just run out and file anything. But again, if it's a hazard and you got kids around, you may not have a choice. But if you can, contact that company, contact the city, and you're doing the right thing by at least trying to get them out there. Let's say it takes a while. Your next step would be either to go to a council meeting, or you can file. It's a statute of non-claim. So if you file against the city for damaging your property, you got a 6-month statute of limitations called statute of non-claims. And usually statutes in Alabama are 2 years, 6 years, something like that. But be careful, something against the city, it requires an internal statute of limitations. Against the county, it's 1 year. So there's paperwork you have to file. So I'd give it a few weeks, be patient, be polite, but also be persistent and try and get that remedied on your property, which is certainly you're entitled to.
City council person might be somebody to talk to as well, wouldn't you think?
A lot of times they can get things done if it's in their district and they're responsive, like a lot of them are.
Yeah.
They can be an interface and help you go and talk with someone from the city to try and get that set up. Usually the company wants to stay in good graces with the city, so I'd be surprised if they don't come out and remedy that. And then they're at risk of losing contracts with the city if they get a reputation, for not correcting or mitigating the damage they cause. Even though we get it, sometimes you got to cause damage to dig up those lines and whatnot. But part of the deal is repair what you damage.
Kind of similar. We got a text question in. If you're cutting the yard and you fall into the septic tank hole, is the landlord responsible for your injury? So if you got a septic tank cover that's not secure enough, what do you think?
So if it's on your property, and so a homeowner, let's go back to premises liability. If you're an invitee, they owe you the highest. There's 3 levels. A trespasser, well, you don't owe a duty to a trespasser. You can't set spring guns or a trap, but other than that, you don't owe no duty. Licensee, they come on the property for their benefit, or an invitee, such as a guest. You have a guest on your property, you have a duty to warn them about hazards you know about or should know about, right? And if you fail to do that, you are liable if they're injured. If it's not open and obvious, there's several other defenses. A licensee, they're on your property to benefit the landowner, but also benefit themselves. You have a duty to warn about known dangers. If you fail to do that, you as the homeowner can be liable. Now, in this case, it's city property, arguably, even though it's on your property. If the city is responsible for that area, they could be liable. But again, we want to find out who has ownership and control, and usually that's the homeowner. We're talking about a septic tank within the boundaries of your property. So make sure to check your stuff, check your property, and if someone's injured and you knew that and you did not warn them about that, you could be liable. So if you're the one who was injured, you can make a claim with a homeowner's carrier, because again, this doesn't mean they're a criminal, but if they fail to warn you and you were injured, you're entitled to your medical bills paid, compensatory. Let's say you're off work because of that injury for a year. You're entitled to your compensatory damages to put you back in the position you would be had you not been injured. And if there's any type of pain and suffering, you may be awarded something for that, given and that's usually relative to the degree of negligence.
Yeah.
And
if you fell into a septic tank, I'm thinking there's some pain and definitely some suffering.
Right?
Right.
Yeah, that doesn't sound good at all.
We've got Remy on the line with a question from Huntsville. Hi, Remy. Thanks for calling. What's your question tonight?
Hi, Sharon. Hi, Will.
Hey,
Remy.
how are you tonight?
Oh, good. I'm glad you had this free-for-all kind of show tonight. I was in Wyoming last year with a brand-new pickup truck, and one of those sludge, that oil sludge that they're getting, the oil sands, the truck is coming from the opposite direction, and it threw off this, like, chunk of tar with rocks in it that was hit so hard. I had a cattle catcher on the front of the truck. It actually dented that, and then another piece dented the hood of the truck.
Wow.
And then subsequent to that, and I had a dash camera on, and subsequent to that, I've had other vehicles like these dump trucks. They'll say stay back 200 feet or whatever.
Yeah. Driving
down Highway 72, going through Huntsville or whatever. And I've had rocks come off of there and crack the windshield. If you've got a $250 deductible and the windshield's going to be $350, you know what I'm saying? They're only paying $100 for your insurance, and the rest is out of your pocket. Do you have any recourse against those people?
You know, if you're lucky to get a windshield for $350 these days, right? You know, so a couple scenarios. So the one where you're behind the truck and they fail to secure their cargo and it's falling out the back, you know, they'll ask you to stay. Is that a law? Because they ask you to stay 200 feet back? No, it's not. That's a request. But if they've got rock stuff falling out of the truck and it hits your vehicle, they are responsible for failing to secure their load. The officers do a great job, and they're trying to regulate, pull these guys over if it's not tarped properly, if it's not secured properly, because that's a hazard to you. Everybody else is on the road. So you can make a claim. You can go against your own carrier, make that claim, and your carrier may go after them. But if they won't, then it's up to you to go after the trucking company. Now, let's talk about your first scenario. You're riding down the road, and the car in the opposite direction slings mud, gravel, whatnot onto you. I don't know if that's going to be negligence from that other driver, because that other driver's operating on the roadway that's not closed. It's an open roadway. Now, the municipality could be liable. Let's say there's a pothole on the road, you hit it. A lot of times, if you have damage to your vehicle, the city municipality is responsible for repairing that vehicle, and you make a claim with the city attorney, the county, whichever one has control and custody of those roads, right? And so you could make a claim against them, but not against the other driver, because again, that driver is just operating on the roadway that's open. And so I don't see any negligence there. So on your first scenario, you'd have to go against the municipality. And the second, it would be against a trucking company that failed to secure their load. And we've had cases like this, Sharon, where tires come off. I had a client who lost an eye. A tire, came off the truck, went through his windshield.
Ooh.
Wood coming off, logs coming off, all those type of things.
Yeah.
And it gets serious when you talk about the weight that some of these heavy trucks, are loading. And there's specific DOT guidelines and regulations with regard to how to strap that stuff down, how to secure your load. And it's serious business. And hopefully it's just a cracked windshield or whatnot, but we've had death cases and horrific injury cases, and just like the video tonight where, the truck lost control of its trailer. Trailers are just coming unattached. A lot of people on the road, a lot of people doing their summertime stuff. Like we talked about earlier, make sure you're securing your stuff, because if you don't have enough coverage, you're personally liable for that. And so it gets real fast, not only for the victims, but for the ones who caused it.
Good luck with it, Remy. Thanks for watching. We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I was in an auto accident a little over 2 years ago with I was driving with two other cars.
Okay.
And while the police came out, we filed. I gave my name, my address, my phone number, insurance cards, all that. And I later on turned it over to my insurance company, and it was a minor amount of damage, and I didn't think I was at fault, so I didn't make any claim on it. Just wanted to make sure the insurance company knew about it. Well, I just found out it's a little over 2 years, and one of the drivers filed a lawsuit against the other driver, and they didn't name me, but what they did was they named something to the effect of additional fictitious defendants A to Z, whose names will be added. And what I want to know is, since more than 2 years have passed, can they bring me back in under the statute of limitations by saying fictitious defendants, or since they knew who I was, am I free of a statute of limitations claim?
Well, your last part of that question was essential to your question. They knew who you were at the time, okay? So let's talk about, it's called notice pleading. And so pleadings in Alabama, you're to put the defendant on notice of what you claim he or she did wrong or violated the law and what damage you recovered. Now, the statute of limitations is 2 years in Alabama. Breach of contract or underinsured motorist is 6 years, but again, 2 years is safe to assume that would apply in this particular case, all right? And so the attorney who files that case is under an obligation to do his reasonable due diligence to determine which all defendants are out there and comply with the applicable statute of limitations. And so the fictitious parties allow the attorneys and the parties to bring in other defendants if they're not reasonably known, if they could not have been discovered early on or within that 2-year statute of limitations. So the civil procedural rules allow you to plead fictitious defendants that through discovery, you find out someone else was actually at fault or could be liable, then you can amend your complaint and that would comply with the statute of limitations. In your particular case, they knew who you were, they failed to file, so your lawyer will argue and your insurance company will hire you a lawyer to defend you in this case, if you are named. But the first order of business will be a motion to dismiss for failure to comply with the applicable statute of limitations, and fictitious parties would not extend that statute of limitations to add you to the case because the lawyer and the parties knew or should have known that you were a potential defendant at that time and they failed to name you. So you should be okay, but if you do get served, make sure to contact your insurance carrier and they'll hire you an attorney to defend you and make those arguments and many others, actually.
Until he is actually named, he doesn't have to do anything about this, right?
Not really. He could be subpoenaed to testify, but in terms of his own liability,
Yeah.
I don't see it at this point.
Yeah.
And sounds like he's okay, knock on wood, but again, facts could dictate otherwise, but that's what it seems like at this time. So good luck to you, Howie.
We got this email question from Laura. Laura says, my sister had a wreck with her 3-year-old son in the car with her. She has whiplash and back problems and aggravated a pre-existing condition. Her son, 3 years old, has 2 knots on his head from banging it on the car seat, and he's complaining about knee pain. The doctor says he's fine. Her son is handled separately from her, correct? So what should she be expecting in trying to settle this case?
Okay, let's talk about the sister first.
Okay.
So she had a pre-existing condition. And so the law basically states that if you have an injury that predated that particular wreck, and that injury was not exacerbated or made worse, you don't have a claim. But the law is, it's called an eggshell plaintiff. You take the plaintiff as you find him or her. So this particular sister has a pre-existing, let's say, neck injury, and then she's in a wreck, and that neck injury gets worse or aggravated. Then you take the doctor's deposition, you get the medical records to prove that that pre-existing condition was aggravated or exacerbated by this new trauma or wreck. And what is the extent of that? And so the jury and judge can consider this new evidence, and she can make a claim for these new injuries. Let's face it, we've all got injuries. As you live life, you accumulate them, unfortunately. But the law still allows you to recover if those pre-existing conditions are exacerbated. And now the 3-year-old, she mentioned, knots to the head. Do you want to see the medical records? There's a lot of literature out on TBI, traumatic brain injury. And anytime you have a knock, there is some element of TBI. When you talk about, dizzy, headaches, things like that. There's medicine now, or the medicine that you can have a blood test and biomarkers can show what the nature and extent of your particular concussion or TBI, because a concussion is a traumatic brain injury of some level. And so with everybody, but with young kids especially, you want to make sure that you vet, or you allow that child time to heal, and let's make sure we know everything about that injury and make sure he or she is 100% recovery. To the extent they're not, now, we just talked in the last question about statute of limitations. For a child, Sharon, it's 2 years after the 19th birthday, and that's to protect the kids out there, because oftentimes you don't know, and they're not able to make a claim at this time. So we want to give them time, A, to evaluate their injuries, and B, to make their own decision with regard to if they want to pursue a claim. And so we advise clients to take their time, get better. Let's listen to the doctor, look at the diagnostic studies, and see how you progress and make sure you recover fully. To the extent you don't, then you want to assess that in any lawsuit you file or claim you make. And so they are treated separate. Each case is separate. The sisters has a claim for personal injuries, and the child has a claim for personal injury. If the child case is resolved, you have to have what's called a pro-ami hearing, and that's, again, to protect the child. The court will appoint a guardian ad litem to be the advocate of only the child, and will vet the plaintiff's attorney's work, as well as the nature, extent of the settlement, and make sure it's in the benefit of that child. Now, let's say you got a 3-year-old and you make a $100,000 recovery for that child. You can't give it to a 3-year-old, so you have to set up an account, an interest-bearing account, either with the court, or have a guardian be appointed to secure those funds in the best interest of those child, and that will be monitored by the court until the child is the age of majority or whatever the contract states. And so there's different legalities and hurdles to settling a case for a minor.
We've got Joe on the line with a question from Albertville. Hi, Joe. Thanks for calling in. What's your question tonight? Hey, Joe, are you still with us? Joe from Albertville? Joe from Albertville, what's your question tonight?
Yes.
Hi there.
Yes, ma'am. I'm still here.
Great.
Hey, Joe.
Thanks for calling. What's your question tonight?
I was wondering if, just say someone got caught for DUI today and they ain't had a DUI in 20 years, could that DUI that they got 20 years ago still be held against them?
All right. So the law kind of changed. So when I started, I did some criminal work for a short time, and they're telling me I got 1 minute to answer, so let me try and get to it. All right, so you want to go talk to a criminal attorney, A. But B, I don't think so. If you get a DUI, let's say in the 80s, and you weren't given some type of right, they couldn't use that against you if they didn't either have it logged in the computer a certain way. If you have over 5 years, I believe some of them drop off. But again, let's say you get 1 DUI, 2 DUI, your 3rd could be a felony, your 4th could be a felony. So you want to make sure that they don't accumulate. So I would sit down with a criminal attorney, and if you got a DUI today, they're going to go back and see if that's going to be an enhanced punishment for you. I believe, off the cuff, I think it's enough time to where you're not going to get hamstrung by a a prior conviction. But that's something to sit down, because you want to make sure, because even if it was counted against you, if certain procedural requirements were not met, it can't be used against you.
We're going to take a break. We'll be right back answering more of your questions. It's Ask Us Anything night. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Will League with Timberlake, League & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And our very own Sharon Doviet, family law attorney, divorce, child custody, Huntsville, Alabama, or anywhere in North Alabama, 256-539-7337, SharonFamilyLaw.com.
Thanks for all your calls and questions, and have a safe week.
Good night.